I'll start with you. I must say, in my day, I've been to a few of these things. It's a great good time. There's a lot of partying with antitrust lawyers. Get a bunch of hundreds of antitrust lawyers together. It's really fun. What was the big story?
You know, I think the big story was that we're all agreeing to disagree, much like what's happening in antitrust world, much like what's happening in the FTC hearings and what's happening kind of in academia right now. You know, there's so much talk about this new movement or this challenge to antitrust laws and policy and the question of whether antitrust has been too lax over the last 50 years or so and resulted in, you know, industries that are too concentrated in great big, huge, powerful internet platforms that are gaining more and more power and control over us and over our data every single day. And I think there's just a lot of debate about whether there is a problem, isn't a problem, and if there is a problem, what do we do about it?
So Lisa, what about it? I don't remember a time in recent years, at least, when antitrust has been such a political issue. You read Politico now, and they've got all long discourses on antitrust law as possibly being part of the 2020 election. Is it because of Amazon and Google and Facebook and the power they have? And did the antitrust laws fail us?
Well, certainly I don't think the antitrust laws have failed us because I'm an antitrust lawyer, but that aside, I mean, I think one of the things about this meeting year on year is it's becoming increasingly more global. And, you know, of 3,500 lawyers that were there, some 1,500, I think, were from outside the US. Wow. And so this dialogue is expanding beyond what's happening here to what's happening internationally. And technology, of course, has accelerated that. I think that the problem, if there is a problem that we have in the US, is that we are a common law country, and what the regulators can do and what plaintiffs can do with the antitrust law is bounded by the Supreme Court and appellate court decisions. And so, you know, when people say, well, look at Europe, you know, Margrethe Vestager is up there talking about, you know, the big fines against Google and their proceedings against Intel. Why aren't we doing that? And the answer lies in, you know, the very high standards that we have for monopolization, Section 2 offenses here in the U.S.
But the courts interpret the statutes as written. I mean, the antitrust law originally was statutory. It's the Sherman Act, it's the Clayton Act.
But
so
have you read it?
But if Congress, I have.
It's very short. It's very short.
But that can be changed. It can be changed. And there is, I think, a legitimate question here whether the structure for antitrust laws that were set up for railroads and oil monopolies and things like that apply in this new competitive technology world. For this simple reason, the thought has been, it's a question of does it raise the price for consumers? Much of what we're seeing in technology is actually deflationary. It makes things cheaper, and yet we get amazing concentration of power. Should we be concerned about that? And maybe we need to change the law and not just change the enforcement.
Well, that's one approach, although once you start trying to tailor particular legislation to meet a particular technology problem or something like that, you know, you end up in a dead end there once the technology moves on and develops. And I think the antitrust laws were fairly deliberately designed to be very general and very flexible, and they have been developed over time. Now, I think even the European Section 101, 102, I don't think that those are specifically tailored to meet, you know, specific issues either. But it's where the courts and the regulators take those laws.
But the French and German governments have some views about changing that law too, as I understand it, right? For some different reasons. So, Jen, let's turn to a second subject, which is vertical mergers, basically, which came up certainly in the AT&T case with Time Warner. As I understand, there's something of a debate about changing the rules on that, or the approach, the guidelines? Yeah,
there was a lot of talk about vertical mergers. In fact, I attended a panel that Lisl moderated talking about the AT&T case and vertical mergers in general. It was very interesting. The issue is that the Department of Justice strongly believes that the guidelines that they follow when they assess a vertical deal to determine whether they think it's anti-competitive should be changed. Those guidelines are from 1984. And according to the Department of Justice and the enforcers that spoke, they have no relevancy anymore at all to today's world and today's market and market dynamics. The Federal Trade Commission seems to be a little more tentative about whether that needs to be done or not and what the right approach is. And I think the problem is that most see that vertical mergers are very complicated. And to the extent that they can cause harm in a market, it's a complicated assessment, and it's not the same from merger to merger.
But why does it make it different, Lisa, whether it's vertical or it's horizontal? We should just look at the markets and say, is it getting too concentrated or not? Are you making it more concentrated? It doesn't matter if it's vertical or horizontal. Well, who cares?
Well, it does. When you define a market for antitrust purposes, you consider, you know, what the effective active area of competition between the companies is. And in a vertical deal, those companies don't actually compete directly. So that complicates the analysis. In a horizontal deal, it's easy to see that, one company is selling, potato chips and so is the other company, and them getting together concentrates the potato chips market. In a vertical deal, though, there's no actual increasing concentration at either level of the market. It's the vertical integration between the markets that's potentially causing, and the biggest harm here that we're focusing on is foreclosure. Is this causing foreclosure? Is this going to raise rivals' costs in one of the markets? Is it going to deny an essential input? Is it going to deny somebody on the upper level of the market access to a channel of distribution? Those are the kinds of harms that we're looking at in the vertical context.
Which the Justice Department tried to argue in AT&T Time Warner and got their head handed to them. One more. Let's talk about state attorneys general.
Okay.
And I must say, if I knew that states could enforce the Clayton Act, I think I forgot it. So because when I heard that, in fact, the T-Mobile Sprint deal might be challenged by state attorneys general, I said, well, what difference does that make? It's up to the Justice Department and the FTC. It turns out it's not that simple.
No, that's right. The Supreme Court actually said in the 1970s that the states have the right to seek an injunction to block a merger. And usually, if they are going to do something like that, they do that as a block because they can pool their resources. It works better for them that way. And they have actually done that a few times in history and successfully had some success.
And this is a way for politics to come back into antitrust law to some extent, because we have some attorneys general right now who have a different point of view from the Republican administration. And this could really lead to some real active litigation.
Well, I think that the states have really picked up the mantle. At the beginning of the Trump administration, there was a concern that antitrust had not been given the focus or the primacy that it had in the prior administration. And certainly initially, the attorneys general were out there talking, and the antitrust bureau chiefs talking about being more active on that front. And they certainly have. I mean, you see it in industries like healthcare in particular, where you not only have the antitrust enforcers involved, but insurance commissioners and those type of regulatory entities. And then now we're seeing it in deals like Sprint T-Mo. For the most part, when states go after a deal, they usually do it in conjunction with the federal authority. So there haven't been that many states on their own going here.
Or when you see them, they do it because it has an impact just on their state, like California, a refinery deal in California. One
last quick one. One place where the antitrust enforcers apparently are very active, at least the Justice Department, and that is in policing the Oscars.
Yes,
we're now hearing reports that Mr. Delrahim has written a little note to the people who manage the Oscars and say, wait a second, Mr. Spielberg doesn't want Netflix in here anymore. You can't exclude him. I never thought we'd have antitrust applied to the Oscars.
Well, it is surprising, and I think, maybe people wonder why is the Department of Justice spending their time writing letters to the Oscars? But the Oscars, that Academy of Arts and Sciences, are comprised of competitors, and they are competitors to Netflix. And if they band together to issue a rule that hampers Netflix or harms Netflix, that is what you call a group boycott under the antitrust laws, and it is unlawful. So they have a point. The Department of Justice has a point here.